Yes, Lordship, on behalf of the petition, Lordship.
Yes, what is the correction?
In the order, Lordship, second paragraph, first line, Lordship, if the petitioner, Lordship, it's to be if the opposite party, Lordship.
In the second paragraph of the order dated 11/6/2025, the sentence starting with inverted comma, if the petitioner and the state intends ... should be read as if the opposite party and the state intends ... The same should be read as part and parcel of the order dated 11/6/2025. Department is directed A to incorporate necessary corrections.
Yes, ma'am. Two I am for the state, ma'am.
But I'm for the petitioner. Lordship, yesterday, my lord has asked the investigating officer to be present.
Yes.
With respect to the videography, my lord.
Yes.
Yes, ma'am. Very good.
Yes.
This is the videograph and what is before the trial court, my lord.
When?
This is the report.
12/6/2025. When was the seizure made?
Yesterday.
Huh?
Yes, ma'am.
Seizure made yesterday?
Yes, ma'am.
Huh? Yesterday?
Yes,
Seizure made yesterday?
yesterday.
No, seizure.
Season, the videograph.
The videography was when?
Yes, my lord. It was seized yesterday.
The case is of
5th of January.
5th of January. You have only retrieved yesterday.
Yes, my lord.
It's not that now you are showing that. It's a news story, not a news story. That was there in the mobile.
Yes,
You are
there is no-
retrieving that only.
Yes, my lord.
Lord, in
There
the
is a-
charge sheet,
there is-
Lord, there is no
There is
mention.
another copy of the.
There is no mention.
So that you are doing, they have now deposited in court.
Yes, ma'am.
My lord, after this issue was raised before this honorable court, and my lord, it was.
Sir, videography, if it is done at the spot, will distinguish if it is subsequent, with the accused will be shown over there. Try to understand.
Yes.
This is by way of a report which they have already submitted to the court below also.
Yes, ma'am.
Additional district and session judge fast court.
Lord, yesterday.
So
After,
that retrieving was done yesterday.
so my lord, there has to be, my lord, the proper seizure. As per the charge sheet was filed without the seizure of the videography.
Without videography was not filed. Search and seizure, videography was done on that date. The
Yes.
retrieving was done only yesterday.
And
There is nothing wrong in that, sir.
That they are alleging, they are saying, my lord, that
So
it was
that
done.
becomes a disputed question of fact. You can raise a question over there regarding the fact that this is not the same videography of the, but then there will be materials to the effect. Somebody has given certificate, taken the
yes, ma'am.
onus of giving certificate.
And in the FIR it is mentioned.
Giving him a copy. I'm just. Sure.
My lord, another, my lord, I have pointed out yesterday, my lord, in the seizure list, kindly see once, my lord, that it was seized from only one of the accused persons. And my lord,
Joint position is
my
there.
lord, that is not there, my lord, kindly see from whom seized.
From whom seized the person was there.
Page number 13.
Signatures are there, ma'am.
Page number 13.
Have you taken up the point earlier, sir? In the court below, in any
My lord, in the
data-
trial court, I have stated this, but the court, my lord, the difficulty is they do not record the submissions.
There must be an averment in the petition. Petition
That is the difficulty, my lord. Even the orders are not passed in open court. That is the difficulty. After
the petition, there must be a point to that effect.
That I do not have the bail petition, but my lord, this is a valid point, lordship.
The valid point of trial, I'm not saying every point is a valid point, sir. But we've got to appreciate whether the section 37 rigors are overcome or not. As
And
simple
my
as
lord, the quantity is also not mentioned. Charge sheet is filed. Now, my lord, how they, my lord, it will be said that this is under commercial quantity.
मतलब 3,941 pieces of Yaba tablet.
that MG is how much?
CFSL report is there, my lord. But
No, CFSL report confirms is a Yaba tablet.
yes, my lord.
Doesn't say regarding the weight, whether it's a intermediate quantity, commercial quantity, or a small quantity.
Let 3,941 pieces.
What is the quantity?
Methamphetamine 50 grams is the commercial.
Huh?
Above 50 is the commercial quantity.
3,900.
These tablets, blood, if I assume it is 1 mg, one tablet, then it is 4 gram, 3 gram. But this cannot be decided on assumptions. The prosecution has to prove that what is the weight.
The strip mentions anything? The strip
No,
mentions.
it's in the packet.
But the strip mentions anything?
No. It comes in a packet, not in a strip.
Comes in a packet?
Yes, ma'am.
So why haven't you weighed that, sir?
Wait. There is.
But it is not the case that it cannot be weighed. Milord has seen lots of cases where it is quantified in grams.
That
Yes.
has to be either if see these are loose tablets. Now, so far as the CFSL report is concerned, that matches with the psychotropic substance. I've got no issues regarding that. But there must be a clarification for us to know whether it's a small quantity,
Yes,
intermediate quantity, or
My lord.
Thirty-five. 35. In the inventory, at the time of inventory.
so 138 kgs, 2000 kgs gaja you can weigh. And this you cannot weigh.
When how many pieces? They counted the pieces from them. 3,900, almost 400. 4,000.
50
mg is the
50 gram is commercial. The 1 mg को तो 4 gram है.
Ritwik, give me the case there. Drugs are disposed of, or are they in custody? Seizure.
It is in custody.
We
But
can produce.
My lord, every lacuna, my lord.
So not like sir, presumption 35 and 54 is running against you. Huge number of tablets. At this stage, 35 and 54 is running against you. কাজ করবে সব।
My lord, that has to be done in presence of a magistrate at least, my lord. What they will do?
Do it before an executive magistrate or a judicial magistrate.
My lord, judicial magistrate, kindly, my lord.
I'm directing.
yes. Kindly fix it on Tuesday.
Wednesday, I'm keeping them at.
My lord, my lord, my lord.
It's difficult. These three districts, Kujbihar, Malda, and Dinajpur. I'm there in the drug disposal committee of the High Court also. The three main districts which are creating problems.
I have also repeatedly, I have also very distressed regarding that.
Rather, I find Alipurduar is doing work well.
Yes,
Alipurduar.
absolutely, Alipurduar doing well.
No, either they don't have training or no, I don't know. These are the minimum things required when you are doing an investigation under the NDPS Act. Although 3941 numbers of Yaba-like tablets, Yaba-like tablet were seized in course of investigation of Shitolkuchi EPS case number 05/A25. There has been no payment of the say aid tablets. Full stop. The same since the seized items are already in custody of the police authorities. The same should be weighed in presence of judicial magistrate after taking permission from the special court. Achha. So far as the report relating to videography is concerned, I find that the contention which was initially advanced in the letter of complaint has been substantiated by retrieving the videography of the seizure from the mobile phone, and the video footage has been also certified under the relevant provisions of law. Full stop. Let there be compliance of the AAS order, and a fresh report be submitted before the AAS court on 18th of June 2025 when the bail application will appear under the same heading. Chalo. Reports are submitted, be kept with the record.
Grateful.
Item 3 and 4 on the same page, there is 2 coactives, my lord, 23 kgs of gaja.
Earlier bail was granted for any accused.
Yes, my lord, 1 accused granted bail, my lord.
So the petitioner is in custody since 25th of September.
Yes,
Huh?
September, my lord.
Not
25th September 2000.
25th of September 2024. And the prosecution case reflects that 23.0200 kg of contraband of ganja were recovered from the possession, from the joint possession of the petitioner and others. Full stop. Learned advocate 8 for the state submits since commercial quantity of contraband has been seized. The petitioner should not be released on bail, and there is a need for custodial trial. Full stop. I've considered the submission of the learned advocate for the state as well as the head of the petitioner, and having regard to the period of detention and the quantum so seized, I am of the view that further detention of the petitioner is unwarranted. Accordingly, the prayer for bail of the petitioner is allowed. Consequently, the petitioner would furnish bond of rupees 20. Consequently, the petitioner would furnish bond to the satisfaction of the learned aid. Learned special judge under the NDPS Act, Jalpaiguri. The quantum of the bond would be assessed by, would be fixed by the learned special court. However, one of the surety must be a local surety. So far as the local surety is concerned, the same must be furnished by way of title deed of property of a person who is residing within the jurisdiction of the learned special court. If on bail, the petitioner shall make herself available on each and every date so fixed by the trial court, and will not and will cooperate with the progress of the case.
But actually, this petitioner was the resident of that.
The local surety will be there. What is it? It is further directed that in case goes away, I am asking for forfeiture of the property. As simple as that. Otherwise, people will not understand. In case there is any violation of the condition of bail, the learned special court would forfeit the property which is furnished by way of local surety. The learned special court is also directed that in case of any non-compliance of the aforesaid conditions, the learned special court would be at liberty to cancel the bail without further reference to this court. Which one, Convent Road or this Jalpaiguri? Jalpaiguri is better, I have heard. For Gaja, what setup you require? Jalpaiguri better, I have heard that. Then Convent Road is overburdened. For psychotropic substances, you send to Calcutta, it is all right. For Gaja, why will we send to it? Gaja, how much time it takes to taste?
But as because of the Excel report has not been obtained, this was constrained by the charge sheet without several reminders are
Acha, the investigating officer is directed that না, the investigating officer দিলে হবে না, এটা কোন district? জলপাইগুড়ি. The superintendent of police Jalpaiguri would take up the issue relating to furnishing of FSL report by the director, state forensic, director of the testing laboratory. Since the expert report is pending for a considerable period of time, the concerned laboratory would ensure that in a period of 30 days from date of communication by the superintendent of police, the report is furnished before is either handed over to the investigating officer or furnished before the special court.
And if
এটাকে allow করুন, CRM NDPS 228 of 2025 is allowed. Next, same case.
same.
পরেরটা কি, চার নম্বরটা একই অর্ডার হয়ে যাবে। And he handed over to the investigating officer or furnished before the station.
Number 5.
Sure, I'm for the petitioner.
Amount to the special court কে ছেড়ে দিয়েছে।
Lordship, admittedly, the petitioner is a driver of a commercial vehicle.
ওই অ্যামাউন্টে, হ্যাঁ। Yes.
Lordship, admittedly, the petitioner is a driver of a commercial vehicle. The vehicle was plying in between Shiliguri and Sikkim. By two passengers were there, one Arun Thakur and another Avinash Gupta. If Lordship sees the page 9, the written complaint, the last 3 lines of the second last paragraph, item number 1 and 2, that is the contraband articles found in a red color poly bag styled as Adidas, kept in the middle seat behind the driver's seat of the vehicle in between Arjun Thakur and Avinash Gupta. So the two passengers who were traveling kept the bag in between them. And what was found, Lordship? It was found 12 bottles of
Your investigation is going on a company.
The case was started in February. Charge sheet yet not been submitted.
That's why I'm asking you investigation.
And they are the driver and the khalas.
no Kalashi.
Driver,
No, only driver.
They are the three persons. One is the passenger, supposed to be a student, he got paid. But the status of this petitioner is totally different, your lordship. As because one is a driver, he's conscious police, he knows better than which contraband carried in this vehicle, your lordship. And the very initial stage, your lordship, and the trial court 7625, the petition for releasing the vehicle. And CS content for only down your lordship, can you see the order passed by your coordinate page that he is a student, mere student, that's why without your lordship was kind enough to read. But the so far the question is the driver.
to come after,
Commercial quantity.
always, come after.
Lordship, one. Kalashi is the order dated 23/4/2025. Because Lordship, all the time it is seen that this plea were taken for
Order 20.
certified copy, Lordship, last rejection order 23/4/2025. Whether these point have been adjudicated in before the trial court or not. Kindly see, Lordship, in the middle portion, learned counsel for the accused Krishna Prasad alias Gora submits before the court that nothing had been seized from the possession of the accused, and moreover, he is a driver by profession and was carrying the accused person as passengers in his taxi, having no knowledge about the transportation of narcotic substance by them. Now, Lordship, kindly appreciate one point, Lordship. Being a driver, it is not possible for a driver to scan the articles carried by the passenger who hired my vehicle, Lordship.
And there is three persons, one is the driver, another.
Let me find out first.
Lordship, this is the document. There is a commercial vehicle.
No, that's coming, I've seen, that's the case of the prosecution also. sir.
Lordship.
Let the investigation be completed and grant you liberty after submission.
Lordship.
So, Lordship. Learned advocate appearing for the petitioner submits that petitioner is a driver of a commercial vehicle who has been implicated in connection with the incident case without any fault of his own, and the contraband which were seized were not to the knowledge of the present petitioner by the present petitioner, which was kept at which was kept in the middle seat behind the driver's seat
In between the,
in the other two accused persons. Other two has been arrested.
yes, it.
In between the other two accused persons who were flying the vehicle, full stop. As such, learned advocate prays that on any condition, the petitioner may be released on bail. Learned advocate for the state opposite is prayer for bail and submits the investigation of the case is in progress. The contraband which were contraband bracket S which were seized are above commercial quantity.
Little above, Lordship.
Consequently, at this stage, I am not inclined to really is the petitioner on bail, as the rigors of section 37 of the NDPA is attracted. However, the petitioner would be at liberty to approach this court after the report in final form is submitted before the judiciary.
Grateful, Lordship. Grateful.
Number 6.
Dismiss. Yellow.
Lordship, I am on the behalf of the petitioner, Lordship. This is the NDPS matter, Lordship, and very first bail application before the Honorable Lordship. Lordship, I am falsely implicated under section 27B2 and 28A of NDPS Act, Lordship. Lordship, I am in custody for around four years, Lordship. And Lordship, second, Lordship, on page number 10, Lordship, that is the memo of arrest, Lordship.
What have you done regarding execution of the warrant of arrest?
My lord, next date is still fixed for execution report of the warrant of
So there
arrest.
was no persuasion on behalf of the prosecution.
My lord, a
23
report is
7
required in that regard.
23/7/2021, the person is arrested. You have 16 bottles of maybe cough syrup and 30 strips of inspasm. You are from where? Which district?
District Darjeeling, Lordship.
Darjeeling.
Lordship, there is violation of section 50 as there is,
Let a report be
uh,
called for from the investigating officer as to what steps
Lordship,
they have taken.
Lordship, there,
রাখা যাবে না
Lordship.
3 বছর ধরে 4 বছর হতে চললো কিছু
Lordship.
অবস্থায় ঠিক
বাইরে থেকে ট্যাপ
what report you will do? You will not split up the trial also. Local shield থেকে ছেড়ে দিয়ে সেকেন্ড টাইম এসে কি করবে? Learned advocate appearing for the petitioner submits that the petitioner was arrested on no bail jump, no, he's throughout in custody. No?
Yes, yes.
কি বললাম? On 23rd of July 2021, and since the end he is in custody. And since then he is in custody. And there has been no progress in the case after submission of the charge sheet. Good stuff. learned advocate appearing for the state submits that as another accused person has been absconding in and warrant of arrest has been issued till date, the trial could not proceed. However, the prosecution, according to the learned advocate for the state, prosecution is making sincere efforts for arresting the absconding accused. Be that as it may, the petitioner is in custody for 3 years, 11 months. Having considered the period of detention of the petitioner, I am of the view that further detention is unwarranted. Accordingly, a petitioner, according to the prayer for bail of the petitioner is allowed. Also, petitioner shall furnish bond of furnish bond to the satisfaction of the learned special court. NDPS Act, Siliguri, packet ADJ second court for the quantum of the bond would be fixed of the learned special court. However, one of the two sureties বলেছি ওটা by furnishing ওটা যেটা দিবা would furnish bond. However, one of the surety should be a local surety who would furnish title deed of property, which would be forfeited in case the petitioner violates the evades the process of law or violates the directions of the learned trial court so far as progress of the trial of the case is concerned. Good stop. Next, the petitioner is further directed to make himself available on each and every day fixed by the learned trial court. And to cooperate with the progress of the case. Next, in case of violation of any condition, the learned trial court would be at liberty to cancel the bail without further reference to the court. Accordingly, CRM NDP is number 236 of 2025 is allowed. Allow any can only.
Lordship, sorry for the interruption. Lordship, kindly give that local surety within the jurisdiction of Darjeeling State.
Of special court that we know. Special court has Siliguri is something. Huh?
Lordship, Lordship.
There is a special
There's a
court.
special code in Darjeeling also. There's a special code in Siliguri for the Siliguri subdivision.
Local surety within the district of Darjeeling.
Not to leave the jurisdiction of the trial court.
বাড়ি চলে যাবে আবার হয়তো ফরফিচারের ডিরেকশন দিয়ে দিয়েছি
But 73 bottles of cough syrup was recovered from the petitioner. But charge was framed on 13 May 2025. I mean custody of
witnesses.
Malad.
There is a scissor list charge sheet.
Charge sheet wala page starts from page 19.
আচ্ছা
Malad 7 witnesses one.
page 21.
1021.
Page 21. 3 independent witnesses.
Yes, Malad.
11 CS witness total.
Malad.
But there is no 2, 3 and 4 are independent
witnesses.
witnesses.
See the witness.
2, 3 CSW 2, 3 and 4 are the independent witnesses.
Lordship.
Hmm?
2, 3. Mainly 2, 3.
And 4 is what?
Inventory videographer.
ও দরকার নেই
2, 3 is main.
come after the evidence of two
And
and three.
Lordship, only one submission. This is the third case, NDPS case he's having.
Additional, we have also collected the.
Antecedents.
Yes, Lordship. In, before
They are the special.
সেটি তখন বলবে কোন।
Yes, and.
I'm recording that, but you must also approach for it.
Lordship, Lordship,
I cannot take away the right.
Lordship.
Learned advocate appearing for the petitioner submits that the petitioner was arrested on 17th of November 2024, and in spite of charge having been framed in connection with the incident case, only CSW1 has been examined.
No, no, ma'am, no witnesses.
No witness has been examined till date.
18/6.
Learned advocate submits that there is no possibility of the trial being completed in near future. As such, the petitioner should be released on bail. Learned advocate for the state submits that there are other similar cases against the petitioner, and the petitioner happens to be a history cheater. However, having considered the plight of the plight expressed by the learned advocate for the petitioner, and the fact now এটা আমার observation হয়েছে আরেকটু বলো ওই আর দুটো লাইন দাও the seizure in the present case according to the state is of commercial quantity, and as such the rigors of section 37 of the NDPS Act is attracted. However, having considered the progress of the case, I direct that the petitioner would be at liberty to renew his prayer for bail after the evidence of CSW 1, 2, and 3 is over. At this stage, the prayer for bail being CRM NDPS number 238 of 2025 is dismissed. Who is appearing? My lord. Who is appearing in this matter?
Not today only, just CD has not yet been.
Bail jump किसे अब CD किया हुआ? Case of bail jumping. Bail jump तो.
Bail jump. Only 1 kilogram 900 gram ganja.
1 kilogram.
Yes, 1.9 kg of ganja. Local surety.
Landed property.
Petitioner has approached the court with a prayer for bail, and the learned advocate submits that
My lord, landed property, I am a illiterate and backward area person.
backward area property will also be taken by the court.
I have no land in my name.
So why are you evading, sir? Bail jump case I will not grant without local surety and property is being submitted. Equivalent. That initially the petitioner was released on bail. However, because of miscommunication, he did not appear, and the bail was cancelled pursuant to a harsher process of law being issued, and subsequently subsequently harsher process of law has been issued, and the petitioner has been taken into custody. Learned advocate for the state vehemently opposes the bill and submits that the petitioner has misused the liberty granted to him, and only for his absence, the trial of the case is pending since the year 2020. I have considered the submission of the respective advocates appearing for the petitioner and the state, and having regard to the quantum of seizure, I direct that the petitioner would be at liberty. I am of the view that the petitioner's bail in connection with the instant case should be allowed. As such, the petitioner shall furnish bond of rupee is 20,000 with two sureties of like amount each, one of whom must be local to the satisfaction of the learning aid. Special court being the special court under NDPS Act, being the Learning Additional District and Session Judge, First Court, Jalpaiguri. So far as the local surety is concerned, the CAA must be by an individual who would furnish the title deed of property, and the same would be forfeited in case in future the petitioner violates the directions and or evades the process of law. Full stop. The learned trial court is further directed that in case of violation of any condition, so impose the learned trial court would cancel the bail without further reference to the AS code.
I'm grateful.
With the aforesaid observations, CRM NDPA AS 242 of 2025 is allowed. Sir.
My lord, I am for the petitioner. 9.5 kilo gaja was recovered along with 160 bottle of pencil. My lord.
First, the big
Just-
item has to be mentioned first, no, 160 bottles of pencil
Pencil.
and with
Investigation is continuing.
9.5 kg. My lord, charge sheet has not been filed. It's a case of 2nd of April, madam. It's too early,
Chalo,
premature.
learned advocate-
My lord, once have.
I want to teach you, come after the charge sheet is submitted. Sir. The learned advocate appearing for the petitioner submits that the petitioner has been falsely implicated in connection with the incident case for alleged recovery of the armed contraband. Full stop. Learned advocate for the state submits that 160 bottles of fentanyl in cough syrup along with 9.5 kg of ganja were recovered allegedly from the possession of the petitioner. How many accused?
My lord, they are only arrested one accused, another 3 accused was not arrested.
I'm sorry. From the allegedly from the petitioner and others.
Total 5 accused, 4 are absconded.
I find that the investigation of the case is still in progress, as the same has commenced on 2nd of April 2025. Having considered the stage of the case, I'm not inclined to interfere. I'm not inclined to interfere. I am not inclined to consider the prayer for bail at this stage. Consequently, CRM NDPS number 243 of 2025 is dismissed. Petitioner would be at liberty to approach the court after the submission of charge sheet before the jurisdictional special court.
Okay.
Lordship, in item number 10, kindly fix it on Tuesday, Lordship. No case diary.
Data লিখে দিন 17 What I will do tomorrow?
So I am for the petitioner. Lordship, it's a renewal prayer for bail, Lordship. Lordship, 20 kg 500 gram ganja was allegedly recovered, Lordship.
Yes.
Charge sheet
20
submitted,
kgs,
Lordship.
yes, Lordship. 20 kgs, 500 grams ganja, Lordship.
Arrested on 30th August 2024.
Yes.
How many
Yes,
accused
yes.
persons? Do it in the next circuit. Your
Yeah, we
Number
did,
one.
Lordship.
Yes, Lordship.
on 13th May, your application was rejected by the High Court.
Four accused persons.
You see over here.
Soul.
So, your Mamata Barman,
Yes, Mamta Barman.
1 মাসও হয়নি রিজেক্ট করেছে।
Lordship, 50 years.
Huh?
Today is the 13th, just.
Do it in the next circuit. I've got no issues regarding the quantum, but see, close proximity of time, a court takes a different view. And you have agitated all the points. I'm placing this before the next circuit. Otherwise, I don't have any issues regarding ordinary courts. I would have granted, but see, the earlier bench has only in close proximity of time rejected the prayer for bail.
But Lordship, charge sheet submitted, 50 years old lady. Lordship.
When charge sheet was submitted.
Charge sheet submitted, Lordship, 25th to 25.
So then the order of rejection is of 13th of May. এত short এতে বেরলে খুব মুশকিল।
That's it submitted without CFSL report also.
Next available circuit will be given. Since I find that on 13/5/2025, the prayer for bail was considered urged by a coordinate age and the same was rejected. I'm not inclined to take up the bail application within such close proximity of time. As such, the prayer for, as such, the bail application may be placed before the next available circuit.
50 years old lady also.
Four was
Next
before
circuit-
Justice Rao also.
Next circuit was due was dependent.
Four was before Justice Rao also. কি করবো ম্যাডাম? I'm not rejecting your application, keeping it in the next circuit only.
Difficulties on next circuit on that.
That you have got to accept, sir. This is High Court.
I'm applying for the petitioner mallet.
Yes.
It's a matter relating to 6 spokes and the service mallet is not affected. And can it be taken up on Tuesday? In the meantime, mallet.
In the meantime, you give a copy Yes, we do. When have you served?
In the case under section 307,
Oh, 307.
my lord.
Yes, my lord. My lord, but the injuries are simple and
Pradesh.
they, yes, yes, yes.
দেখি চার্জশিট সাবমিটেড তো
Yes, my lord.
2021 কেস প্রোক্লেমেশন হয়নি?
No, no.
We had been granted
There
bail,
are
my lord.
total 35 FIR name accused persons.
বিরাট
My lord, I'm holding the CD, my lord.
ইনজুরি রিপোর্ট show me.
My lord may find out from the petition itself, my lord, from
Okay.
page number 14.
14.
16, sorry. Simple.
Nah, there are, my lord, total there are 7 injuries as per the CD, my lord. Out of them, it's fact that 1, 2, 3, 4, 5. These 5 injury reports, the nature of injury is simple. 6, page number 95, it's written seems to be serious. Page number 95.
And-
that is of Hossein Ali. And one Motihar Rahman who was treated in a private hospital. Later on, his injury report is there. He was admitted for quite a long time.
But my lord, we had been granted bail, my lord. And just for a wrong posting of date, my lord, that warrant of issue had been issued.
You were granted bail.
Yes, earlier we had been granted bail, my lord. That has been annexed, my lord. Just for one posting of wrong date, my lord, it's a matter of sheer bad luck, my lord. Just one communication, my lord. Cap.
Come in revision, why are you doing this anticipatory?
My lord, we initially it was done in this could be done, my lord. We have order, previously it was done, my lord. My lord.
Previously it was done মানে?
No, my previously the anticipatory bail was granted in bail jump.
Against the warrant.
Yes. On 3 occasions by this Calcutta High Court, my lord. By
Then I
this
have got to assess the misuse also. Whether the orders have been misused also. 438 is apprehension. With submission of charge sheet, there is no apprehension, confirmation. Then if you don't go and warrant of arrest is issued, regularly you will come and get anticipatory bail. So the degree of misuse has to be assessed.
My lord, it's only one date of we have been miscommunicated, my lord.
Case of 2021, no progress has been made.
My lord, we have
Yes, when did you surrender? Which page?
My lord, we had
আচারউদ্দিন এটা আছে সেশনস কোর্ট অর্ডার দিয়েছিল
yes, my lord.
তারপর when did you surrender? Where is that? Order of bail by the trial court?
My lord, it is in page number 15, my lord.
1-5.
Yes. No, my lord, we haven't annexed that order, my lord.
Then
My lord, kindly grant us a leave.
file a supplementary affidavit.
I will file a supplementary affidavit.
File a supplementary affidavit incorporating all the orders from the date when you surrendered.
The date, my lord.
জীবনে করবে না এগুলো অ্যান্টিসিপেটিভ বিল। আচ্ছা petitioner learned advocate petitioner is directed to submit file a supplementary affidavit incorporating all the orders from the date on which the petitioners earlier surrendered before the learned jurisdictional court till the warrant of arrest was issued.
My lord.
Full stop. How many days?
My lord, keeps it on Wednesday, my lord.
Thursday. Give a Wednesday a copy to him.
Very well, my lords.
A copy of the supplementary affidavit be handed over to the learned advocate appearing for the state by 18th of June 2025. List the application for anticipatory bail on 19th of June 2025 under the same meeting.
But 23 were kindly taken up on Monday, man.
No,
But I am not ready with that to take instruction.
which instruction? Injury report is there. Yes. What happened? What is the nature of injury? তাহলে কবে সোমবার তুমি করো। হ্যাঁ I did not today রেখে দিন না সোমবার তো Monday do it sir Monday এর মধ্যে যা টাকা পয়সা নেবার নিয়ে নিন
Matter relates to POXO, my lord. Service not yet effected. Keeps it on any day on the next week.
To hand over a copy to the learned advocate appearing for the state. He'll effect to service as usual. I'm passing directions in all the matter. Give a copy to him to the officer in charge of the concerned police station.
We'll give you a copy in a due course of the
At
day.
due course of the day. ওই অর্ডারটা করে দেবে তুমি নিয়েছো এই অর্ডার তো হ্যাঁ ওই অর্ডার করে দেবে when do you want which police station
Which, on Bokshirat police station.
Bokshirat
My lord, may I make, my lord, may I make one request? Can this 22, item number 22 be passed over for a while? I have just received this certified copy of all the orders.
so you have got to file a supplementary affidavit.
Very well, very well, very well.
I'll do it. No issue. In this circuit, I'll complete the matter.
My lord, sir.
ওই একই অর্ডার করে দিচ্ছে 18th I'm keeping the matter, this matter.
Yes.
18th.
Yes, my lord.
18 তারিখ দেখে দেন Next.
Lordship, I'm for the petitioner.
Yes,
Case is
what happened?
registered under NDPS Act, Lordship. Nothing was recovered from my position.
Monday,
Lordship.
not today.
I'm for the petition.
Who is for the state? Very good.
Or the victim has not been served yet, can it be served through state?
Yes, ওই same order করে দেবে 18th
Wednesday, ma'am.
fixed Tuesday. Which police station?
It was, Kuchbihar, my lord, shop.
18th থাকবে পুলিশ 18th 18 তারিখ অর্ডার করে দিচ্ছি বুঝতে পারলেন তো
Service to.
চলো ঘুরে আসি তো on
Accused arrested on 19th April, Lordship, and 98 bottle of codeine was seized from the custody of the principal accused, Lordship. Yes, Lordship.
Only statement of co-accused, what is
Yes,
the
Lordship.
actual? Learned advocate, it appearing in for the petitioner submits that the petitioner has been implicated in connection with the instant case on the basis is of statement of co-accused and nothing incriminating has been seized as such by the police authorities, or there are any other materials for the petitioner for any custodial detention. As such, the petitioner may be released on anticipatory bail. Learned advocate for the state, on the other hand, submits that 98 bottles of Blurex tea, BLUREX, put the capital dash T, cough syrup were recovered from one Mrinal alias Kunal Roy and the said accused specifically named the present petitioner. Be that as it may, since the case diary do not contain any other materials except the statement of the co-accused, I am of the view that at custodial interrogation of the petitioner is unwarranted. As such, the prayer for anticipatory bail is allowed. The petitioner shall ওই একই conditions দিয়ে দেবেন, তাহলে তার সাথে একটা দিয়ে দেবে যে the petitioner shall meet with the investigating officer once in a week till further orders being modified by the learned special court. Local will be there. This is the arresting officer, not the court even.
Even
Any
at
sir?
the time, he was in Delhi, Lordship.
আর কি করা যাবে? Next, who's coming?
And I'm for the petitioner.
Yes.
My lord, allegation under section 341, 323, 326, 506, 34, my lord. Dispute between the, my lord, parties regarding, my lord, supply of the water in their agricultural
আর
land, my
কি
lord.
হবে? What is the injury report? কি করেছে? মাথা ফাটিয়ে দিয়েছে নাকি?
No, no, my lord. My instruction is, my lord, one lady has been sustained injury due to, my lord, she slipped down. Slipped down, my lord. Fell down on the ground, not for the assault. Not by the assault, my lord. He fell down on the ground. My instruction is that, my lord. Due to slippery. On the same day, she was discharged from the hospital, my lord.
Incident when?
Incident,
February?
my lord, 22nd of March, 2025, my lord.
February.
February? Yes, yes, my lord, February. কি রে, ভুল লিখেছিস তো?
PS case number ভুল দিয়েছে।
ভুল লিখেছিস তো?
What is your PS case number, sir?
My lord, 161.
কি করে মার্চ হবে? ইনজুরি রিপোর্ট ফেব্রুয়ারি দেখাচ্ছে।
23rd of March.
Sir, clarify from an investigating officer. You see the injury report is of February, case is registered on March.
March, yes, my lord, 23rd of March.
How many days after the incident this is been reported?
My lord, incident, কি রে, ভুলভাল তো সব। My lord, kindly see page 12, my lord, of my application. In the written part, incident was 12 of February 2025. And case was registered. When is? 22nd of February.
ঠিকই তো আছে, তাহলে আর অসুবিধা কোথায়?
After 1 month.
22nd of February only
Yeah,
the
incident was happened.
The incident is of the same, the medical is of the same date. FIR is a
1 month delay, Marat. 23rd of March.
বাধা নিষেধ করবে। আমার ছেলেকে ধরিয়ে চর থাপ্পড় লাঠি ঘুষে ধাক্কা ধাক্কি করে দেবে।
The 22 days.
আমার জমির উপর তিন অধিকারী is not injured, এটা পড়ে গিয়ে হয়েছে তো।
Yes, Marat.
কিছু দিয়ে মানেনি তো।
Yes, Marat. Yes.
So somebody intended to, the intention is a factor in a criminal case, sir. Pushed, fell down, there is a result. One thing. Using a deadly weapon, a wooden stick may be also a deadly weapon. So using some weapon to injure somebody, as the criminal case is not going criminal, for that he'll go to custody. ধাক্কাধাক্কিতে পড়ে গিয়ে সব রকমই হতে পারে, মরেও যেতে পারে। 304 is also possible. I don't think he is required in custody for this, sir. Custody is required, in custody নিয়ে কি করবে? Learned advocate appearing for the petitioner submits that the petitioner has been falsely implicated in connection with the has been implicated in connection with the instant case, as there was a dispute in relation to supply of water with the family of the de facto complainant. There was no intention to inflict any specific injury. However, out of a scuffle, the petitioner fell, the injured fell down and sustained injury. Learned advocate for the state has produced a case diary. I have perused the medical report. Although the injury referred to is grievous, but the background of the case reflects that there was a scuffle when the injured intended to save the son of the de facto complainant, consequent to which she fell down, and there was a blunt trauma at the right shoulder. Also, it has been alleged also that there are some dislocation in the right hand. However, having considered the genesis of the incident, I am of the view that although the petitioner has involvement in the in connection with the instant criminal case, but the custodial detention of the petitioner may not be warranted in the facts and circumstances of the case. As such, the prayer for anticipatory bail is allowed. Petitioner shall furnish bond of rupees 20,000 with two sureties of like amount each বলে যা আছে সব দিয়ে দেবে, ঠিক আছে? এই যা বেশি কন্ডিশনের পাড়া ঝামেলা। Accordingly, CRM, as and when called for করে দেবেন। এই কি করবে, পাড়ার ঝামেলা রোজই লাগবে, আবার জল দিয়ে ঝামেলা লাগবে। Accordingly, ACRMA 374 of 2025 is allowed. Joe?
Madam, I am for the petitioner. Madam.
Yes.
Madam, 41 kilo gaja has been
Yes, yes.
recovered from 6 accused persons. They,
Not today. Next. 30, 30, 30. 30 who's appearing? এই কালিম্পংয়ের অ্যাড্রেসটা দিচ্ছে না। Where is the learned advocate?
number 32.
Kindly make it short passover.
Hmm. Short means short.
I am calling the conductor advocate.
Producer. আমিও জানি, আর শেষই করে দেবো আজকে। এটা পাসওয়ার্ড রাখুন, ওঠার আগে ডাকবো লাস্ট ম্যাটারের পর। Who is for the state?
Lordship, the petitioners here, petition number 1 is the father-in-law of the deceased.
অ্যাপিল তো কি আছে, হাইকোর্টের এটা কোথায়?
Petition number 2 is brother-in-law,
You are only convicted under 498A34.
not 490, only is Lordship 304, 5 years. And the principal accused under 302, the appeal has been preferred before the revision bench. Lordship. Kindly comes to Lordship,
ঠিক আছে,
page 27 of the judgment.
টার্ম ইমপ্রিজনমেন্ট তো।
And Lordship, I was all along, I was granted anticipatory bail by High Court. This is the order, Lordship.
Sir, term imprisonment 5 years, I am granting them bail. Term imprisonment তো 5 বছরের।
Right declarationটা কাটতে দিচ্ছে।
Principal accused, yes, আমার কিছু
Petitioner, appellant number 1 is the father-in-law.
father-in-law, Lordship,
Appellant number 2 is a
brother-in-law,
brother-in-law. And appellant number 3 is
wife
the
of brother-in-law.
wife of the brother-in-law. They have been sentenced in connection with sessions case number 30 of oblique 2013 and convicted aid for offences under section 304/34 of the Indian Penal Code to serve out imprisonment RI for 5 years along with fine of rupees 10,000 and each ID 6 months further imprisonment. Having considered the fact that the sentence so imposed is for a fixed period of time and the paperbooks are yet to be prepared, as also the fact that the petitioners were all along on bail and had been in facing the trial diligently, I am inclined to release the petitioners on bail in spite of the objection raised by the state. Accordingly, the petitioners would furnish bond of rupees 20,000 with 2 sureties of like amount, each one of whom must be local, to the satisfaction of the learned, which magistrate is which?
Lordship, this is Alipurduar.
Learned CJ Malipurduar. Full stop. The petitioner number, the appellant numbers 1 and 2 would, the appellants would once in a month appear before the learned trial court, being the learned additional district and sessions judge, first track, second court, Alipurduar. The the office of the learned trial court would maintain records regarding the regular appearance of the appellants and once in every 6 months, submit a report before the court in respect of the regular attendance of the accused of the appellants as directed above. Accordingly, PRN 1 of 2025 is allowed. Department, however, is directed to adhere to the directions passed on 10/6/2025 by calling for the trial court records and prepare the paper books within the schedule so directed.
Deeply obliged, Lordship.
Milord, I am for the petitioner, Milord. I have come before your Lordship Court for the quashing of the FIR, Milord, and lost by my in-law, Milord, after the demise of my husband, Milord. My husband was a patient of depression, Milord. I would like to request the court to.
Where is the charge sheet? Charge sheet submitted, you are coming for quashing of the FIR unnecessarily.
Charge sheet, page number.
The charge sheet submitted, where are the 207 papers? Where is the suicide note? Show me.
Milord, charge sheet,
Where is the suicide note? There is a suicidal note.
sorry, Lordship.
Why do you come at this stage, sir, quashing of the FIR?
Milord,
the
this
stage to-
this suicide note was lodged, this found, or he had that mentioned in the suicide note prior to the suicide of
Where is
6
it?
months.
Where is it, sir?
It is not here, Milord, but it is mentioned in the complaint, Milord, page number 18 onwards, Milord, in the last paragraph,
You are sticking to the complaint now, evidence has been collected.
Milord.
I
But phase of this
Huh?
this is dispute between the wife and husband, allegation against his wife and the paternal relatives of the wife side, Milord. 8 people have been charged sheeted on the strength of the suicide note, Milord, written 6 months prior to the suicide, Milord. And it is similar to it attracts the judgment Prakash and others, but it's
After consideration of the charges. take up an appeal.
Milord, there is this warrant against me also, Milord. That is, let this case diary be produced before the court, Milord. Kindly, Milord. I am a teacher, Milord. I have got 4 years old daughter, Milord. I am the only one to look after that, Milord.
Sir, how a criminal division for quashing is to be filed,
Milord.
You are filing all
There is no
applications.
case. I have filed this civil case also because this.
You do everything, sir.
Milord.
Inherent powers cannot be arbitrarily exercised by the High Court.
Milord. Kindly,
Where is the warrant of arrest? You were granted bail earlier.
No, it was not given. I haven't gone to the course in the court in the
Have you been served with a notice under section 35(3) of 41?
No, Milord.
Huh?
No notice was served.
Go before the court, I am saying the warrant of arrest. Petitioner claims that he is innocent of the let somebody appear for the state, sir. কিছু নেই মামলাগুলোতে ভাট করে চলে আসে 207 দেবে না কিছু দেবে না আমি কি বললাম he is innocent of the charges and has been implicated as an absconding accused in the charge sheet submitted in connection with Bhoktinagar PS case number 502 of 2023 dated 8/19/2023. Full stop. Although the revisional application has been preferred for quashing of the proceedings, however, quashing of the FIR, however, as the charge sheet has been submitted and none of the documents under section 207 of the Code of Criminal Procedure has been enclosed along with the revisional application, I am of the view that the prayers so advanced for quashing cannot be considered by this court at this stage. Full stop. Learned advocate submits that warrant of arrest has been issued. Sorry can be one, sir. frivolous applications filing, learn the craft of the court and thereafter accept the profession. Only wearing black robes don't make you an advocate. Repeatedly, why will it be happening? Why are you carrying something which you cannot handle?
Sorry, I can.
Equivalent against the petitioner. Let the execution of the let a copy of the revisional application be served upon Mr. Sarkar, an advocate appearing on behalf of the state. Full stop. The warrant of arrest is so issued against the petitioner be stayed for a period of 4 weeks. In the meantime, if the petitioner surrenders and prays for bail, the learned aid magistrate would consider the application of bail of the petitioner in accordance with law. Sure. With the aforesaid observation, CRR 255 of 2025 is disposed of. Several copies. Grateful minute. Huh? Approval. 23. Yes.
Lordship, I am for the petitioner. Here in this case, I am praying for setting aside the warrant of arrest order passed on 13th of March 2025, Lordship, by the Chief Judicial Magistrate Jalpaiguri. Lordship, the case is of under section 411 and 413 of IPC.
Of 2000.
2014, Lordship. But they were in bail lastly.
Not lastly, for number of dates you were not appearing. See the previous dates also. Not very good conduct.
Lordship,
Although it's saying for 2 weeks, you go and surrender.
Lordship,
Yeah, appear could be. Petitioner is aid to hand over a copy of the revisional application upon Mr. Chakraborty, learned advocate who ordinarily appears on behalf of the state. His appointment may be recognized by the concerned authorities. Learned advocate appearing for the petitioner undertakes that the petitioner is ready and willing to appear before the learned CJAM Jalpaiguri. However, he apprehends that he may be taken into custody as warrant of arrest has been issued by the learned court. Having considered the undertaking given by the learned aid lawyer, I direct that that the warrant of arrest is so issued by the learned aid court, learned aid CJM Jalpaiguri in connection with Nagrakata PS case number 136/2014 be kept in abeyance. Kept in abeyance till 27th of June 2025. In case the petitioner appears before the court, the learned aid trial court on the learned CJM Jalpaiguri on furnishing a local surety by the petitioner who would consider his application for bail in accordance with law. With the aforesaid observation, CRR 263 of 2025 is disposed of. Server copies.
Let's appear for the petitioner. My lords, in this case, my lords, the FIR, I'm challenging the FIR and subsequent proceedings. Charge sheet has been filed. Supply has not been done, my lords.
To come after that, after agitating all the points.
My lords, but kindly hear me, my lords. This case, my lords, stems out of a pure vendetta, my lords.
All
my
cases
only-
are out of vendetta.
My lords, kindly appreciate, my lords. My only mistake, what I did was I represented the de facto complainant's husband before the trial court in the divorce proceedings, my lords. That is why I've been entangled in this case. My lords, kindly see
You
the
don't
FIR
have the
for a moment.
documents. FIR I cannot consider. FIR doesn't exist today, sir.
Yes.
After submission of charge sheet, FIR
Then,
doesn't
let's
exist.
kindly allow me to withdraw this. I'll come back. Okay, stage.
Take back the certified copy, sir.
Very well, very well.
Petitioner. Learned advocate appearing for the petitioner intends to not press the present and revisional application and prays for liberty to file afresh.
Very well.
Anybody will appear for the state.
Not
Huh? What was it that to bill? A copy of the revisional application be served upon Mr. Loksam, learned advocate who ordinarily appears so the state is appears to be regularized by the concerned authorities. In view of the submissions answered by the learned advocate appearing for the petitioner, CR 264 of 2025 is dismissed as not pressed. Liberty is granted aid to the petitioner to approach to file afresh with all the documents under section 207 of the Code of Criminal Procedure. Full stop. Director दिए दाओ. Department is directed aid to return the certified copy after the same is replaced with a photostat copy.
I'm grateful. 35, Lordship, I've got the report.
Yes.
I've got the report.
If somebody was appearing through VC,
Warrant of arrest has been issued, Lordship.
like that's another ACS issued warrant which was challenging the president, but the revision left. When is the next date? 12/6. For the correct the local period.
Surrender.
March.
Warrant of issued with
Who is the petitioner?
for 29.
কেউ আছে দেখুন তো রাজেশ কুমার শর্মা হ্যাঁ nobody is appearing. What to do?
Not today. What to do? Report has been given, Lordship. Report has been given, Lordship can pass necessary orders, Lordship.
I don't know. দাঁড়াচ্ছে না কেন সেটাই তো মুশকিল I'm directing to surrender within 4 weeks. So what is the purpose? চলে আসুন Mr. Duksam, learned advocate appearing for the state has submitted a report which reflects that the warrant of arrest is still pending and the police authorities till late could not execute the warrant of arrest. Having considered the same, that subsequent harsher process of law has not been subsequent harsher process of law has not been issued by the learned AJM Siliguri. I direct that in case the petitioner appears before the learned aid ACJM Siliguri in connection with Matigada Police Station case number 747 of the 2024. By 11th of July 2025. He may be and prays for bail and prays for fresh bail. Learning aid court would consider the same in accordance with law. It is further directed that the warrant of arrest so issue would be kept in abeyance till 12th of July 2025. The learned aid court would after the learned ACM Siliguri would after the aforesaid period of 12th July is over would revive the warrant of arrest so earlier issued. Full stop. No further extension and be granted aid after the said period is over. Reports are submitted by the state. We kept with the record with the aforesaid observations. CRR 151 of 2025 is disposed of. Sarah copies. Chalo. Who is for the petitioner? Yes.
Yes, I am for the petitioner, my lord. I am for the petitioner.
Yes.
And
Got the case diary?
I don't like to place with the application and I crave leave of the court to.
All right, all right. Learned advocate appearing for the petitioner submits that he do not intend to press the present revisional applications and who would file afresh after receipt of the documents under section 207 of the Code of Criminal Procedure. Learned advocate for the state is present along with the case diary. Accordingly, CRR 181 of 2025 is dismissed as not pressed. Petitioner would be at liberty to file afresh along with the documents under section 207 of the Code of Criminal Procedure. Will learned advocate for the state of Calcutta illegal learned advocate for the state is present along with the case diary করে দেব বলাই আছে তো আওয়াজ ঠিক আছে একজন
So kind.
তো বলেন I লিখে দিন like the department is directed to return the certified copy on the same being replaced by photostat copy. Next.
Item number 37, service is not complete, Lordship. Kindly fix it on Monday, Lordship.
Service is not complete means when was the direction?
We have served, Lordship, but not affected, Lordship. Yet.
You served through the state.
Lordship.
Who is appearing for the state?
Lordship, service is not complete yet.
Upon the state, what complete? So you will go to
State
the
is
office.
also not complete, Lordship. এটা একটা রিপোর্ট কল ফর ছিল লাস্ট ওকেশনে
Report has been received, sir.
Lordship, we have served but not yet.
You have served upon the state.
No,
So why state is what? A foreigner?
no.
Serve in course of the day.
Lordship.
Petitioner is directed to serve a copy of the revisional application on the office of the additional public prosecutor, High Court Calcutta, at the circuit bench Jalpaiguri in course of the day. A separate copy be served for the purposes of informing the opposite party number 2. Acha. State would take endeavor for serving a notice on the opposite party number 2 by informing the opposite party number 2 through the officer in charge of the police station, Moinaguri police station, an acknowledgement in respect of the service being effected be informed by way of submission of a report on 17th of June 2025 when the revisional application will appear under the same heading. Chalo. Acha report report first dewe na. Report so submitted as directed earlier be kept with the record.
Lordship, small indulgence, only one report copy also be served to us.
No, keep it in the court.
But item 38, Lord, I am appearing for the petitioner with Mr. Antariko Basu and others. So on the last Tuesday, Your Lordship wanted us to show document that the petitioner is in custody. Lord, my learned junior, Mr. Hilol Shahapuddar is present in the courtroom. He will show that the petitioner surrendered in trial court on 19th of May. Oh, she was taken into custody. I'm sorry.
The LCR hasn't come. LCR aatke rekhe diyeche.
Petitioner was all along on bail during the conviction and during the pendency of the revision application in High Court.
but going to about professional latches, but the lady is suffering.
Petitioner. Pursuant to the records reflect that the revisional application was dismissed for default on 26th of July 2024, and as a consequence of which the present petitioner, being a lady, has been taken into custody on the basis of warrant of arrest issued. Full stop. The revisional application has been restored to its original style and number. Consequently, I direct that the petitioner be released on bail to the satisfaction of the learned CJM Kuch Bihar. The petitioner would furnish bond of rupees 20,000 with two sureties of like amount each. One of must be local to the satisfaction of the learned CJ. This further directed that the law court records be called for. Conviction is under which section?
The 3 and 6.
206. So tried by assistant sessions judge.
Assistant session judge initially, then the conviction was confirmed by the additional session judge.
Let the law court records be called for, which would include the records of both the learned trial court as well as the learned aid appellate court. The trial court records will lower court. On receipt of the same, the revisional application be listed before the available certificate page under the heading hearing.
Grateful to us.
Accordingly, CRA in 1 of 2025 is allowed for 31. Certified copies so submitted by the learned advocate for the petitioner be kept with the record. So,
Grateful to us. Grateful.
Yes. Where is your, who is appearing for the state? Yes, you look Yes.
Worship, petitioner number 1 is the mother-in-law and the petitioner number 2 is the sister-in-law of the opposite party number 2.
Yes.
My lord, last question, my lord, was please to direct me to find whether the charge sheet has been submitted or not. The charge sheet has already been submitted, my lord, and section 376 has been omitted from the charge sheet. Now the charge sheet has been filed under section 498 and 323, 506, 34, my lord. The CS has been filed on 28/7/2024.
File afresh, sir, after.
207.
I'm giving you both the options. Either agitate the points before the trial court had come, or you can file after receipt of the copies under section.
Lordship, liberty may be given.
Learned advocate appearing for the petitioner has challenged the proceedings arising out of the Bhoktinagar police station case number 923 of the 2023 dated 16/10/2023. Learned advocate submits that the present petitioners happen to be the mother-in-law and sister-in-law of the de facto complaint of the party number 2. Mr. Biswas Lane, advocate appearing on behalf of the state aids that during the pendency of the revisional application, already charge sheet has been submitted before the jurisdictional court on or about 28th of July 2024. It has also been submitted on behalf of the state. That charge sheet has been submitted under section 498, 323, 506, Grade V8, section 34 of the Indian Penal Code. Having considered the fact that the petitioner approached this court for quashing of the FIR and subsequently charge sheet has been submitted, I am of the view that there has been change of circumstances. Consequently, petitioner would be at liberty to approach the court after receipt of the documents under section 207 of the Code of Criminal Procedure, or after praying for or discharge at the stage of consideration of charges before the learning trial court. With the aforesaid observation, CRR number 49 of 2024 is this. Several copies. Or after praying for discharge at the stage of consideration of charges. Next.
40, my lord, I am for the petitioner.
On convenience of Mr. Bhomik, this has been done, sir. He said on any date you choose. Why should he join virtually? Date was fixed. No, then he should not have said that before this. There must be a commitment of an advocate practicing in the High Court.
But your earlier option, 9th January, you have taken CD along with the.
I understand that. Sir, if you will be doing like this, I am the last person to tolerate. I accommodate professionals on personal ground. On that date, I specifically asked him, according to your convenience, you tell me which is your date. This date was fixed according to the convenience of the council. All those hoodwinking don't take place with me. 30 years I am in the criminal court. Monday, if it is not done, I will not dispose of the matter on merits. I will impose huge cost on the advocate, remember. It's your option whether you will appear or not, but for failure of commitment before the court, the lawyer will be penalized.
But she CD already submitted.
Don't take High Court as a district court, I am telling you. Don't spoil the culture of the High Court. Your predecessors over here as lawyers for 30 to 40 years fought for establishment of a circuit bench. Don't spoil that. Not today.
441.
I am for the state in this matter.
In this case also, I think charge sheet has been filed. Same naturally, same order.
Subsequent.
এটা তাহলে একই অর্ডার করে দিন। খালি এটা ক্যানটা ডিসপোজাল করে এই কেস নাম্বারটা খালি বদলে দেওয়ার জন্য বলছি। This is also separate sections. না আমি এটা অর্ডারটা একটু ডিসক্রিপশন দিই। Petitioner approached the AS court challenging the continuance of Pradhannagar or PS case number 425/2024 dated 3/7/2024, which was registered for investigation under section 195A, 325, 354, 379, 506, ZVA 34 or of the Indian Penal Code. However, during the pendency of the present revisional application, which was filed for quashing of the FIR, the investigating agency concluded the investigation and submitted a charge sheet before the jurisdictional court. Same sections.
Section 195A, 323, 354, 379, 506.
Again, then sections have changed. 195A, 323,
354,
354,
379,
379,
506, and 34.
325 you have omitted.
Yes, madam.
Achha. Mr. Biswas Narayana Advocate appearing for the state submits that charge sheet was submitted on or about
31st August 2024.
so after submission of charge sheet to September filing it. 31st of August 2024. And say charge sheet 8 was submitted under sections 195A, 323, 304, 379, 506 and 34 or of the Indian Penal Code.
506 one.
506. Having regard to the stage, having in regard to the change of circumstances, particularly the charge sheet having been submitted and none of the documents under section 207 of the Code of Criminal Procedure having been enclosed along with the present revisional application, I grant liberty to the petitioner to approach the trial court with a prayer for discharge at the stage of consideration of charges, and thereafter approach the if so advised, approach the court with the aforesaid observations. CRR number 372 of 2024 is disposed of. Pending application, if any, is consequently disposed of. Server public.
After my application, charge sheet has been filed.
31st August 6.
You filed an application.
Your filing is on
Pending-
September
September.
and charge sheet was on August. That's why in this case, I have not
Lordship,
granted
that
you.
was beyond my knowledge. That is the-
Very good. In this case, there is a bit change from the earlier order. Earlier, you filed the case during the pendency charge.
during the
sheet.
penalty session.
Now, this was earlier, you did not know, maybe, I don't accuse you for that. But because of that, I have directed that you first file a discharge application and thereafter approach this.
Lordship.
That is not there, is that immediately after 207, you can approach this court.
Lordship. Deeply.
Lordship, on the last occasion, just for recapitulation, Lordship, the petitioner has challenged the order dated 3rd October 2024 regarding the issue of proclamation. And the Lordship was pleased enough to call the report from the police that after the issue of WPA, because the NER was received, and after that WPA was issued. That was the contention of the state. And Lordship was pleased to call for a report, and the report is in the report it has been clearly stated that on 3rd October 2024 proclamation for appearance issued against Mr. Rubel, and on 28/10/2024 the process of proclamation was completed. On 25/11/2024 learned CGM Jalpaiguri committed the case to the learned session judge. The case is presently pending between the learned additional session judge, Third Court Jalpaiguri. 19/7/2025 is fixed for appearance, production and charge.
This split up has been done.
Split up has been done.
Just submit the report, sir. So nothing is there, madam. Your revisional application is not maintainable. Now you can't come for warrant of arrest. Learned aid, pursuant to the earlier direction so passed, state has submitted a report. Report reflects that on 3/10/2024, proclamation for appearance was issued against the petitioner, and on 28/10/2024, the process of proclamation was completed. Subsequently, on 25/11/2021, learned CGM Jalpaiguri committed the case being Kotwali PS case number 377 of the 24 dated 30th May 2024 before the learned aid sessions judge Jalpaiguri. Petitioner has approached the EA's court challenging the order dated August 2024 and 3rd of October 2024. Since the order dated 3rd October 2024 has already been executed, I am of the view that the present revision is not maintainable. Accordingly, CRR 452 of 2024 is dismissed. Reports are submitted by the state. We kept with the reports.
Much obliged.
44 now for the opposite party.
Who is the petitioner who wanted cancellation of bail? Yes. Somebody mentioned the matter. You mentioned the
Yes,
matter.
Your Lordship, I mentioned.
How can you do that?
Lordship, there was a direction of filing the affidavit in opposition, and that is why the matter was mentioned. I'm seeking for submitting this affidavit in opposition.
But if the petitioner is not pursuing the cancellation of bail, who is appearing for the petitioner? This bar or outside?
Lordship, another application for cancellation of bail in connection with this FIR was dismissed for default. I have also annexed that order also.
Oh, that is, who is Mr. Shottum Shorter? The district court culture won't be over here, sir. That I won't allow. You got to take a responsibility when you file a matter. The order for bail was passed when?
25th October 2024. Page number 11.
So it's dated.
Oh, Lordship, this is, I was reading from my opposition.
All right, let this be on Monday. Please, local bar, please serve a notice upon the learned advocate that this will appear on Monday,
Lordship, may I be permitted to?
on that date, madam. If they don't want to continue, I'll dismiss. A simple cancellation of bail is not striking out a liberty now is a question.
Previously, another cancellation of bail in
So
connection.
it's all
with this,
right.
so it's for-
Curtailing of liberty is very tough. Now the issue is that if the lawyer doesn't want to pursue, why should you pursue the matter? এটা not today খালি রেখে দিন। Just in the meantime, Monday, serve a notice upon the learned advocate. Both the matters.
344, both the matters.
Both the matters.
Time for the petitioner, my lord. But copy has been served, my lord, upon the de facto complainant, my lord. But due to insufficient address, my lord, not delivered. Not delivered, due to insufficient address, my lord. POXO matter, my lord.
POXO.
Yes, it's a POXO.
Serve to the state. Hand over a copy to the state.
Already served.
For effective
My lord,
service.
my lord, my lord.
Petitioner is directed A to hand over a copy of the revisional what is this, cancellation or?
No, my lord.
Is it bail?
Bail, my lord, bail.
application, my lord. It's a
Bail
bail
এতদিন
application.
ধরে pending রেখে দিয়েছে।
My lord, the matter was out of list, my lord.
Because you did not appear.
Yes, my lord.
Yes, my lord, that's why it's gone out of. Lastly. it was-
Wednesday, I'm keeping this matter. এটা application for bail এ রেখে দেবেন heading এ। আচ্ছা, petitioner is directed to hand over a copy of the application for bail upon the learned aid advocate aid appearing on behalf of the state. Learned advocate aid for the state would through the inspector in charge oblique officer in charge of which police station?
Police station, my lord,
Shidolkuchi police station, my lord.
Shidolkuchi police.
Shidolkuchi police station FAA service on the opposite party number 2 oblique de facto complainant and furnish a report before the court on 18th of June 2025 when the bail application in the present application would appear under the heading application for bail dash POXO. Give me a copy, huh?
My lord,
Grateful, my lord.
For the status.
I understand.
Yes. Yes, sir.
Lordship, I am for the petitioner. I am not pressing the application.
Learned advocate appearing in বাবা এত বাজে কোর্ট হয়ে গেলাম এতদিন করে রিভিশন অ্যাপিল করে এই অবস্থা আমার কেউ করতে চাইছিলাম আমরা
Actually, whether Lordship will consider the grounds of arrest or not.
Learned advocate appearing for the petitioner do not intend to press the present application. Learned advocate aid for the city is present with the case diary. With the case diary. Accordingly, CRMM 56 of 2025 is dismissed as not pressed. Next. Last chance on Monday, madam. Ask Mr. Bhumik to come, madam. So not today করে দিন সোমবার দিন বুঝে নেবো 48 আছে না একটা
Copy received yesterday.
You are for the opposite party.
No, I am for the petitioner.
Cancellation. And I am for the accused.
Opposition.
Trial commence, my lord, one co accused granted bail by the.
Kindly fix it on Monday, my lord. We will conclude our hearing.
Affidavit in opposition on file on behalf of the petitioner be kept with the
Opposite
record.
party.
Opposite party be kept with the record. State will not appear.
NCB.
My lord, NCB, my lord.
NCB will not appear.
Union of India, my lord. We are for Union of India.
NCB.
NCB.
Oh, you have come up for cancellation.
Yes, ma'am.
Trial is at what stage?
PW1 was partly examined, but November date fixed for further evidence, my lord. Well, I stated in my application, my lord. 18 November.
বুঝিয়ে বেল নিয়ে গেছে নাকি
My lord, the brother of the present OP was.
Alright, you
granted
come
bail.
on Monday.
Yes, ma'am.
But you Union of India কে তো reply file করতে হবে তো without instructions can you do that?
But I will take instruction if the department want to file.
Department will definitely want to department এর format আছে এই সাইজটা হবে না you file your affidavit in reply or you have got to don't do that you take a written undertaking that the department do not want to file affidavit in reply on oral assertion don't do Union of India very dangerous NCB the lawyer এর নামই কমপ্লেন লাগিয়ে দেবে আচ্ছা affidavit affidavit in opposition filed by the opposite party be kept with the record affidavit in reply if any be filed within a period of 2 weeks list the application for cancellation of bail in the next available circuit bench. Yes.
I am for the petitioner.
You are there? Of private opposite party?
Yes.
State who is appearing?
Yesterday, my lord was pleased to direct the state to produce the case diary.
Case under which section?
My lord, lot of section 307, 327, 354, 386, 406.
ঠিক আছে, বুঝলাম। When do you want to do? Monday, ঠিক আছে। Monday, Tuesday, দুদিন টেনে বসে দিলেই সব শেষ হয়ে যাবে। Alright, not today করে দেবে order দিচ্ছি। ফিফটি দেখো কি হলো এগিয়ে যাচ্ছে তো মানডে প্রডিউস নট টুডে কেউ করতে চাইছে না হিয়ারিং নাকি মানে কি হয়েছে আর বসবো না তাহলে যাই যে অবস্থায় আছে আর 10 মিনিট বসে আর
306 matter against the bank officials. Malar wanted to ascertain that there is a injury or not.
All right, file your written notes of argument. I'm giving you time till Wednesday. All right. File your written notes. So there's nothing in this matter. According to me, if you can establish a case, I'll see your written notes of. Very good. You file your written notes of argument according to the, you have received the 207 papers.
Yes.
All right. You file your written notes of argument. Case diary, should I keep it? Then leave it. Photostat, original. When, Tuesday or Wednesday? Wednesday. Ajam. A case diary submitted 8 by the state, we kept with the record. Learned advocate 8 for the petitioner is present. Full stop. Learned advocate 8 for the de facto complainant intends to file written notes of argument. You, madam, you circulate the written notes to them on Tuesday. Wednesday, I'm keeping them, madam. Acha. Learned advocate for the de facto complaint would circulate 8 the written notes of argument on 16th, on 17th of June 2025. List the revisional application under the same heading on same heading কবে দেবো? On 18th of June 2000. তো এ পড়া মুশকিল করতে না no index is there তো ঠিক আছে আমি দেখে নেবো পেজ নাম্বারস 161 ঠিক আছে দেখে নেবো ঠিক আছে দেখে নেবো এ রেখে দিন Yes, Mr. Banerjee, what
I am
happened?
the petitioner, Lordship. Lordship, in this matter, the petitioner before your Lordship is the de facto complainant. On 19th of June 2022, the opposite party number 225 assaulted the father and the brother
What
of
are
the
you wanting?
and FIR was lodged under section 341, 325, 307, 379, 34. After that, charge sheet was submitted under section 447, 323 and 34 of the Indian Penal Code. Although the injury was grievous in nature, head injury was there, the charge sheet was submitted saying that there is simple injury. For that reason, all the bailable sections were given. Against that, we have filed an.
Where is the medical report?
Lordship, I have annexed that, Lordship.
That's why I'm asking you, please. Page?
Lordship. Page 14 is the CT scan report, Lordship.
14. And where is the injury report?
And Lordship, page 15, kindly see.
Yes.
There is the order of the sessions court where it is reflected the injury is grievous in nature, Lordship. The charge sheet has submitted saying that this injury is simple.
No.
Multiple lacunar infraction in left-sided brain stem and side vessel ganglia region.
You have got this case diary, Mr. Yeah. Where is the injury report? You have filed an application 178.
Yes.
Naraji.
That was rejected.
What is the stage of the case now?
Only charge sheet submitted.
Case of 22 charge sheet just submitted. What are you saying?
Lordship?
Case of 2022.
Yes, Lordship. Thereafter, no problem.
Have you recorded the statement? I mean, where from and car কাছে কি place করে state? The abrasion হয়েছে বলছে ও বলছে head injury হয়েছে.
Lordship, kindly see the sessions court order page 50.
And the sessions court order is a bail order. কি লিখেছে? This is a medical report.
So that order was passed after considering the case. Yes. Considering the case diary. You should kindly see the order. May I read out, Lordship?
I've seen that. Mr. Chakraborty, ask your IO to give an explanation, you come to page 14 of the application. এইসব লিখে দিয়ে গন্ডগোল পাকায় প্রাইভেট না প্রাইভেট জায়গা থেকে করিয়েছে the second one from a government doctor give him an opinion what does it mean 2 bottom 1 and 2
Question. Left side brain stem and right vessel can hear.
Absolutely medical term.
So we'll have to.
Ascertain, give it within 2 days, I'll take a decision. এছাড়া তো আর কিছু নেই no call the IO, ask him to get the opinion just what would we is it simple grievous government hospital will just explain what does it mean according to the degree of injury, whether it is simple, grievous, what it is. Very no, but that will be in the that will be a part of the case diary actually. State would seek an explanation through the investigating officer. This is what is bothering you basically. This particular sentence is bothering you. কি বললাম to the investigating officer of the case in respect of the CT scan of brain, particularly with regard to the impression NCCT of brain suggest inverted এর মধ্যে দিয়ে দেবে dot দিয়ে 2 হ্যাঁ এই মাল্টিপল যেটা আছে এটাকে করে দেবে সেকেন্ডটা হ্যাঁ let an opinion be obtained from a doctor belonging into the government hospital. The concerned doctor would state whether the injury referred to is grievous or simple. We are bothered about that only. We are accordingly with 173(8). We will see whether the sections added are simple, proper or not. Nothing more than that. Added. Let the report. Shashik down. So
Further investigation.
then automatically I'll add, sir. Why are you bothered? You are bothered about investigation or the things to be added over? You got to make the
Proper
things,
section have to be added.
Then when should I keep this matter? Thursday I'm giving. It will take some time. I'll dispose this of. Chotu Mamla. List the revisional application under the same heading. Let the report be submitted on 19th of June 2025 when the revisional application will appear under the same heading. একটা পাসওয়ার্ড আছে দেখুন না যদি হয়ে যায় করে দেবো
Lordship.
Item number 30 relaxation.
Lordship was pleased to
কালিম্পং এ থেকেছে না থাকে
Lordship actually
Kalimang
they are not
থাকে।
giving me any proof, Lordship. I've not been supplied till date.
So I am giving you to take out an appropriate application before the jurisdictional court. Go produce the proper documents. The jurisdictional court will exercise its discretion whether the conditions should continue or the conditions should be waived. All right. ফেলে গিয়ে কোনো লাভ নেই বেকার আমি জানি এইসব মক্কেল এরামই হয়
I have communicated to my client, but they're not giving me any documents. I've communicated to my client, but they're not.
I understand, sir. Otherwise, I wouldn't have passed this order. I understand the predicament of a lawyer also. Learned advocate appearing for the petitioner submits that in spite of communicating with the petitioner, he could not receive appropriate instructions, particularly with regard to the address where the petitioner stayed at Kalimpong while he was complying with the conditions so imposed while granting bail. Full stop. In view of the trial of the case pending before the learned special court, I direct the learned special court would exercise his own discretion in case any application for relaxation of condition of bail is made. However, it would be, however, the learned special court would only ensure that the petitioner is available and there is no hindrance in the progress of the trial of the case because of non-cooperation of the petitioner. Chalo. With the aforesaid observations, CRM NDP AS 515 of 2024 along with CRAN 1 of 2025 is disposed of. Sorry. আগেটা হয়ে গেছে বিল পেয়ে গেছিস CRM NDPS 515 হয়ে গেছে কেটে দাও accordingly CRAN 1 of 2025 is disposed. Great.